Hello, everyone, and welcome back to the show. Now is the time for you to get in on the conversation, and we really want to thank all of you out there for sending in your questions via Facebook and Twitter and the email. We've got some great questions, and Judge Terri F is here and ready to answer those questions, and we're going to get to them in just a few moments. But something that we want to clarify for our viewers out there, we have the appellate process at the federal level and at the state level, and you talked a little bit about the parallels between them. But in terms of the process, there's something, it operates differently.
The process is differently state by state, and that's the beauty of the way our system was set up, is that each state has a right to design its court system. Each state designs the way it would like for its court system, and it's pretty much based on the Constitution and the laws that have been enacted in that particular state legislature. So I can't say that Alabama or Mississippi's appellate process would be the same. There will be some similarities, but I cannot say that it will be the same.
That it would be the same. But the appeals, the process within the state operates the same.
Same,
if you go
the process.
We were saying earlier, St. Tammany Parish, Orleans Parish, Ascension Parish, Caddo Parish, it would be the same. But if you're talking about from state to state, it's totally
and there are some local rules that might be different in circuit to circuit, but overall we're guided by the Civil Code, we're guided by the Uniform Rules, and we're guided by the Louisiana State Constitution.
Yeah, and just to add to that just a little bit, it's worth mentioning at this point, within every state there is the state courts, and you are a state court judge, and there's also the federal courts. Federal judges are appointed. Every time there's a federal judge, you see the Senate confirmation hearings on TV and the big debates between the Republicans and the Democrats. But state judges in this state generally are elected, and in other states, some state court judges are appointed. But in Louisiana, there's the state court system, and that is a distinction that I think people might not be clear about.
And I think it's quite different than being appointed for life and serving at the pleasure of the electorate. I serve at the pleasure of the community, and I take that very seriously, and I think all elected judges do. We are not appointed for life, and we must come to the electorate. As an appellate court judge, I have a 10-year term. Appellate court judges have 10 years. Appellate court judge must be licensed to practice law in this state for 10 years prior to being able to run. Because you want your appellate court judges to be seasoned, you want your appellate court judges to have had some experience in the process, because it's an awesome task to be issuing opinions that have the impact that our opinions have on the community. Because in actuality, we are a court of mandatory jurisdiction. That means that every case from the trial court, we are mandated to hear if an appeal is taken. The Supreme Court has what's called discretionary jurisdiction. That means if you're not satisfied with an appellate ruling, you can take a writ to the Supreme Court, but it's their choice as to whether they will hear your case.
And a lot of times they don't want to hear your case.
Well, as I stated earlier, their main role, they are more of a policy court, and their role is to clarify when there are conflicts in the circuit. But I think our Supreme Court, if it had mandatory jurisdiction at some point, and that was changed, just like the U.S. Supreme Court at one point had mandatory jurisdiction, and that was changed. I think justices are given that ability to have discretionary jurisdiction because you want them to be able to look at those cases that will impact. You don't want the Supreme Court retrying every case that's tried in the state.
Absolutely.
And so when you look at that ratio of decisions that are upheld when you get to the appeals process versus those that are overturned or reversed, what are we looking at?
80-20.
80-20. 80% are upheld.
Affirmed. And 20. And I always thought about that, and I was talking to lawyers, and I've spoken to lay people, and it's just like almost like the lottery. You think I'm going to be in that 20%, and that's what keeps our business going. Is that you think you're in that 20%.
Exactly.
But that gets back to what you just said, where the courts of appeal do give great deference or respect to the trial judge's ability to look at the witnesses, listen to the witnesses, weigh the evidence, because they're there. Their eyeballs are on those witnesses, and their ears are right there. And so you're not going to just Monday morning quarterback and look and try and redecide everything. You've got to, in general, you're not going to overturn what the trial court did unless there's an abuse of discretion or manifest error. So it's very difficult to overturn what happens at the trial court,
but
generally speaking.
It is possible.
And
that's the point, and that's the point, and that's
odds.
why the system is put in place for you to have that opportunity. Yeah. But as I stated earlier, there's a respect. And the one thing we haven't discussed, which really also gets that same respect, are the jurors.
Absolutely.
It is hard. The trial judge must have made some error. In a lot of cases, especially in criminal court cases, there's the test of harmless error. So once the jurors have made a decision, it is really hard and for an appellate court to come back and set aside that decision unless there has been some error in the trial court. And trial judges, having been one, are very conscious of that. So if you are in that type of a trial, they will consistently try to preserve the record to make sure, because no one wants to have to retry a case. That's not good for the system. It's not a good use of our time. And I think jurors, that's the one thing that I really would like to commend. And I don't think people really understand the time, the inconvenience, the energy in sitting there as a juror and making a decision, especially in criminal court, that has such an impact. And so we want to respect that.
The decisions that they have made.
And let me say amen to that. And I'm a big believer, and especially with jurors, if a jury is put to that great inconvenience, that great civil contribution, the courts should not take away that decision by peers unless there's a real proof of that manifest error or that
And
abuse of
sometimes that
discretion.
does happen. I mean, it does happen.
Because the system is ran by individuals who are human. And we all make mistakes. You know, I remember when I first began as a trial judge, my interpretation of how something should be implied might have been different from what the Fourth Circuit at that time perceived. Once I received that ruling from the Fourth Circuit, I said, okay, well, this is the way the court wants me to interpret this. It's a process.
It's a process.
And I think we as lawyers and judges, we have to admit that we are constant. We're not perfect. We're going to make errors, but the process is to learn from it, to read, to interpret, and to go from there. When I first was elected judge and I served on the trial court, and my opinions would come back from the Fourth Circuit. If I was affirmed, I was excited. If I was reversed, and I said, okay, let me read and learn from this reversal to see for the next case where we need to go. And it's nothing, and when a trial judge is reversed, or when I'm reversed by the Supreme Court, we don't take it personal. It's all in a day's work.
It's all in a day's work. Well, listen, we are learning so much from you, so I'm so glad that you're going to be back for another show, because there's so much that we have to get into. Let's take some questions from our viewers. First question comes from a viewer who wants to know, do you only hear cases that start from trial courts?
Yes, we do not have original jurisdiction on any matters.
Okay.
We are an appellate, because remember I said we review the record.
The record, right.
So there has to be a record.
Right, so you have to start with the trial court.
Now, I do want to add in one plug for my court now. We're in the process in this technology age of trying to become an e-filing court.
Wonderful.
Well, everything will be done electronically. We're in the stages. It's a process we've been working on for some time, and I think it's something that's very important throughout the state. I think all the circuits, all the trial courts are working on it. So our goal is within the next year or two to be at that level with electronic filing.
It's going to be convenient. It's going to be more efficient.
It should be, but then you're going to still have those judges, and I do it in some cases, where you just can't read from the screen. You have to print it out. You have to print it out. But we want to make it easier for the attorneys to submit it electronically. And then there will be those of us, and as time has gone on, my eyes have gotten to the point where I feel like maybe I do need to print it out, but it will be there, and it's something that I've been spearheading also on our Going Green. We want to be conservative,
sure,
and we want to make sure, but that's one of the things. So if there is no record, there's nothing for us
to review and issue an opinion on. But what if I cannot afford an attorney? I mean, are there any options out there for people who just cannot afford it? We've talked before about just how costly the whole process can be.
Well, in the criminal realm, there are those with the appellate project. There are some. And then in the civil, you do have some of the law schools and some of the legal service projects who will work with you on an appeals.
So you're entitled to free legal assistance if you are accused of a crime and you can't afford help. And in the civil world, there are the law clinics through the law schools and legal assistance. In fact, we put some of this information on the website for this TV show.
But I will say, and I pulled this number earlier, we received 460 pro se writs. And those are individuals who are representing themselves. But the vast majority of those are out of criminal court.
460?
In 1 year.
In 1 year.
Those are individuals who have properly been convicted and are raising issues on their own as representing themselves.
As representing themselves.
We receive quite a few of those pro se writs.
You do, okay. And you hear civil and criminal cases,
Civil,
is that correct?
Criminal, workman's comp. We deal with, and that all falls under, and we deal with the Civil Service Commission.
Okay, all right. Well, Judge, you're going to be back with us next week for our next show. We have lots of questions still that we have not gotten a chance to get to, so we really appreciate that. And I want to remind all of you that you can watch this episode and other episodes of the show, plus sign up for our mailing list. You can join us online at johnredmondpoa.com or jrpoa.com, and you can get every episode of the show delivered to your inbox. You can get information about upcoming shows, giveaways, and so much more.
Remember to follow us on Twitter, like us on Facebook, and write to us by email. Thanks for joining us this week, and we'll see you next time on John Redmann, Power of Attorney.